Good morning, everyone. My name is Patrice Lallam, and I am a program consultant to the Great Plains Institute, which is a regional nonprofit and an energy think tank. We do a lot of work in the carbon management space, and in particular related to carbon capture, utilization, and storage. And as part of our work with 7 states that have signed a CO2 Transport Infrastructure MOU, we are conducting a learning webinar series and are pleased to partner with colleagues at the University of Wyoming for the bulk of the presentation today, and also with the state of Louisiana. Next slide. So with us today, we have some amazing speakers, and I'd just like to briefly share their bios with you prior to getting started. Tara Righetti is one of the lead authors of a paper that studies state policies and regulations of CO2 EOR storage, and that will be the topic of her presentation today. She joined the University of Wyoming College of Law faculty in the fall of 2014, and prior to that, she served as CEO and general counsel of a privately owned upstream oil and gas company with operations in 6 states and on the outer continental shelf. She's admitted to practice in Texas and California and is a certified professional landsman. Following Tara today, we'll get some perspective from the state of Louisiana, and we're pleased to have Blake Canfield with us today. He is the executive counsel for the Louisiana Department of Natural Resources. He manages that agency's legal division and advises the secretary and staff on regulation of Louisiana's abundant natural resources, including but not limited to regulation of activities which impact the state's coastal resources, management of the state's mineral property, water resources, and promotion of energy conservation. And Kipp Coddington is also probably a familiar face to many of you, and we're pleased to have him with us. He's the director at the Center for Energy Regulation and Policy at the University of Wyoming, a chemical engineer and lawyer. Kipp is a low carbon technology and climate policy expert with commercial project and academic research leadership experience. He is a co-principal investigator on more than $12 million worth of projects related to carbon capture and other low carbon technologies. And he separately is funded by private foundations to conduct energy policy assessments. Once our speakers have had the opportunity to present, we will have a facilitated Q&A session at the end. And additionally, the chat feature is available on the bottom of your Zoom screen in your control panel, and feel free to direct questions to speakers and to myself and my colleague Lauren Schultz, who's helping to facilitate this webinar, and we will try to get questions answered. If there are more questions than we have time, we will make sure to save those questions and to get answers to you after the webinar. Next slide. Before we dive in, I just want to say a little bit more about the CO2 Transport MOU signatory states that are hosting this webinar. So there are 7 states that have signed on to date. They include Kansas, Louisiana, Maryland, Montana, Oklahoma, Pennsylvania, and Wyoming. Next slide. And what these states have agreed to jointly work on together is to explore cooperation relative to CO2 transport infrastructure. And coming up here in 2021, the big task before us is to develop an action plan. And that action plan is due to be released on October 1st of 2021. The CO2 Transport Infrastructure MOU went into place on October 1st of 2020. In addition, the states are trying to work together and also work with a lot of stakeholders, including some of you who may be new to this work, on a lot of issues that are of common interest. And so we are doing that here in the first quarter of 2021. We also held a learning webinar series in the fourth quarter of 2020. In addition, we are also working to broaden our stakeholder outreach and also to engage more states in the effort. Next slide. And our work plan, some of which I've already touched on, includes the action plan released later this year and all of the outreach that I also just described. And so anyone interested in learning more about the MOU states and their work and and all of that, please reach out to one of the webinar organizers, Lauren or myself, and we can get you looped into that process. Next slide. So I just wanted to briefly let everyone know that a piece of legislation related to CO2 transport infrastructure was introduced in a bipartisan and bicameral fashion yesterday in Washington, D.C. It's called the SCALE Act. And you can see the list, an impressive list of senators and representatives that were original either sponsors or co-sponsors to the legislation. We are really excited about this bill introduction, and the MOU states are working to finalize a letter of support relative to that bill. Next slide. And so the SCALE Act is really designed to drive infrastructure deployment for transport and storage. It was originally introduced at the end of last year, sort of as a marker bill, and so this reintroduction is really, really important. It builds on the successes of 45Q, the tax credit that is foundational to carbon capture deployment and utilization of storage, and then also the provisions that were included as part of the Energy Act of 2020 that passed late last year. I'm not going to read all the bullets to you, but to say if fully appropriated and utilized, the SCALE Act has the potential to enable $19 billion of combined federal and private investment in CO2 transport and storage infrastructure, and could create approximately 13,000 direct and indirect jobs per year through the 5-year authorization. And that is just the infrastructure piece of the puzzle for carbon capture. So it's really great to see this legislation being introduced and so many people supporting the efforts around it. Next slide. And finally, before I turn it over to Tara, I just wanted to draw your attention to another webinar that is happening next week that's being hosted by the University of Wyoming and the Enhanced Oil Recovery Institute, all about navigating Class 6 well permits and what you can expect in Wyoming relative to that. Wyoming is one of 2 states that the EPA has granted primacy to for Class 6 wells. And so I've included the registration link down at the bottom of the screen here. And again, if you have any questions, reach out to us in the chat or after the webinar, and we can direct you to the registration page for more information. So with that, I think it is my opportunity and privilege to introduce Tara again, who is very, very knowledgeable, to say the least, on the topics of legal liability in pore space. And I am excited and can't wait to learn a lot from Tara today. So with that, take it away. Thanks, Tara.
All right, I'm going to share my screen with you all here. Thanks so much for being here, and I'm very excited to share this work with you and for the great introduction, Patrice. So I work a lot in these different issues and have previously published papers on citing CO2 pipelines, on subsurface trespass, and liability for transboundary migration of injected CO2, and most recently a paper on sort of utilization of federal pore space for these types of storage projects. So I'm very excited to see the momentum on this and how many participants there are who are interested in this today. The subject of this particular presentation is on a study that I prepared together with colleagues at the University of West Virginia over last summer that did a comparative analysis on policies and regulations relative to CO2 EOR and geologic storage. The project included federal lands, an overview of environmental law, and a comparative analysis of 12 states. I'm very glad Blake's on here because Louisiana was not in that initial group of states, but USEA is currently scoping a second phase of this project that will expand the states that were looked at. So if you don't see the state that you're in on here and you're interested, reach out to them. And then we focused really on doing regional analysis, looking at opportunities for further study, trends, and particularly opportunities for multi-state cooperation through things like MOUs or interstate compacts to figure out how to make regional capture, transport, and storage projects possible. Okay, oops, it's not letting me advance my slide. There we are. So the first thing we looked at was the sort of federal land piece and regulatory federalism. This is most important for projects in the West, where you have both federal and private surface and subsurface interests. That includes millions of acres of federal minerals, federal surface in national forests, national parks, and BLM, as well as split estates. Some of the challenges and opportunities that we looked at were challenges with federal permitting processes, particularly from a land management standpoint, some uncertainty of ownership of pore space, issues with preemption between state and federal law, how preferences in multiple mineral development might apply, and then particularly looking at the absence of specific laws that address the land management piece of doing carbon storage projects on federal lands. Those findings are in the USCA report, but they're also in a paper that we have forthcoming with PACE Environmental Law Review. Part of the recommendations that my co-authors and I came up with were incorporating geologic storage into the land planning process, as well as looking at the authority for land management agencies to issue permits for utilization of pore space, and assessing the need for rulemaking, specifically related to geologic storage, which we think would be very helpful for moving this forward. Then we went through state to state comparisons. And for this presentation, I'm going to focus on Pennsylvania and Wyoming as two of the states that we compared, because they are different geologically, as well as in their oil and gas profiles, but both are oil and gas producing states, but they have very different regulatory frameworks in place for CO2 EOR, and also have different constitutional provisions, and the common law has developed differently. In Pennsylvania, there is no statutory regime currently for CO2 sequestration, and there isn't a CO2 distribution network of existing CO2 pipelines. The rules in Pennsylvania for eminent domain authority are limited to public utility corporations, and there's also some uncertainty of ownership of pore space. In Wyoming, which is my home state, there is a state framework for unitization for geologic storage and for pore space ownership. That doesn't resolve all of the issues, but it does provide some clarity. And pore space in Wyoming is considered to be part of the surface estate, but can be severed and separately conveyed. One of the main issues that comes up in projects in Wyoming is the prevalence of federal lands. It is very difficult to think of a commercial scale project for geologic storage that would not include some federal lands, whether surface or minerals. And so uncertainty in how those federal lands can be incorporated into projects and the regulatory frameworks for them certainly adds risk and uncertainty to projects in Wyoming. Wyoming has an existing and growing network of CO2 pipelines and has Class 6 primacy, in contrast to Pennsylvania, where all UIC programs are administered by the EPA. Some other things that are particularly different is in how local regulation would apply. Pennsylvania has a constitutional environmental rights amendment, which has been applied to decisions of the state regarding state trust land, including in the Robinson Township and the Pennsylvania Environmental Defense Foundation cases. And Pennsylvania is part of the Regional Greenhouse Gas Initiative. Wyoming is interesting in terms of transport because its eminent domain laws specifically allow condemnation of rights of way for CO2 pipelines, but because Wyoming has so many coal resources as well as oil and gas resources like Pennsylvania, both states have issues with determining sort of who's on first for multiple mineral development with geologic storage projects. The next part of this presentation is going to go through a series of maps we've made. The states that are highlighted here are the ones that were subject to our initial study. And I think it demonstrates both the heterogeneity within among states and in regions. So even just starting to looking at the dominance of the mineral estate, pretty much under the common law, all states have some version of mineral estate dominance in severed estates, but the approaches between states vary significantly. In some places, it has been modified by case law. In other places, it's been modified by statute, for example, with the Split Estate Act in Wyoming. And in a lot of cases, it's also been modified by both state statute and through case law, such that in, for example, Colorado, in the Rigetti case, the court said that the surface estate and mineral estates are mutually dominant and mutually servient. So while this is unlikely to pose issues with regional coordination when assessing the risk and compensation requirements to owners and the necessity of getting both surface and mineral owners involved in these projects, these state-by-state differences could be important. Pore space ownership also varies between states. The general rule is that pore space is owned by the surface owner. Kentucky used to be the outlier on that with some early case law that indicated that it might be owned by the mineral owner. But since then, Kentucky has enacted statutes which clarify that pore space is vested in the surface owner. But these yellow states here currently have no deciding case law and statute. And while it seems that certainly the trend is towards surface ownership, by no means has that been definitively established. And then even among the states that have clarified either through case law or statute that pore space is owned by the surface owner, there are differences. For example, North Dakota does not allow severance and conveyance of the pore space separate from the surface state, whereas Wyoming does. And so still to determine pore space ownership, it's not enough just to look to these statutes, and an analysis of the actual title and ownership of every parcel within the proposed project would likely be necessary. In terms of subsurface trespass, that is another issue where there's a lot of variation. There's almost no precedent on subsurface trespass in the context of CO2 storage. So what my co-authors and I did here was looked at a review of transboundary fracking cases and produced water disposal cases and chemical disposal cases to try to figure out whether there was clarity on subsurface trespass, whether those claims had been statutorily barred, as they were in North Dakota, although that statute was recently subject to constitutional challenge. And then looking at whether subsurface trespass claims could be brought by a surface owner or a mineral owner. Some of the interesting findings that we saw going through these cases were that courts have generally said that receipt of a permit, an administrative injection permit, There's one case in Texas which says does not give you a get out of tort free card. And so just because you have an injection permit does not necessarily mean that you couldn't be subject to liability for trespass. Though most states seem to apply much more of a nuisance standard than a strict breaking of the close approach to determining trespass liability. Looking here at local regulation, you can see that there is a lot of variation here as well as to whether local governments are expressly allowed to participate in regulation of oil and gas development, whether they are expressly preempted or have some mix of state and local authority. In all states, local governments exercise some authority through zoning, and similarly, no state allows local governments to regulate all aspects of oil and gas development. If we apply this in the context of either CO2 EOR, that creates differences regionally, but then particularly in the context of geologic storage, it's really unknown what authority local governments are going to have to influence the siting of these projects. I'm sure many of you have been following some of the recent pipeline disputes and the challenges that local governments have brought to siting of pipelines. And we believe that those same issues would apply or could apply in transportation of CO2. Eminent domain for pipelines and storage also has a lot of variation. CO2 pipelines are not a natural gas pipeline that's regulated by Ferc under the Natural Gas Act. And so as a result, siting of these pipelines is done on a state-by-state basis, and very few have specific CO2 pipeline regulatory frameworks. Some require CO2 pipeline operators to operate as common carriers. Others do not and allow private carriage. And then use like anti-kilo laws that were developed after the Kilo case may also limit use of eminent domain by private parties to condemn CO2 pipelines for private CO2 storage. So this is an area, and Patrice can share a paper I wrote on citing carbon dioxide pipelines that gets into a lot more detail here about how these inconsistencies may make it necessary to have either regional coordination or federal backstop siting authority in order to create CO2 pipelines in a regional basis for these projects. And then getting into whether you can unitize pore space for geologic storage. Right now, there are only 4 states that expressly have programs that allow unitization of pore space for geologic storage. That means combining all of the subsurface property interests in your area of review and treating them as one parcel, for lack of a better word, in which everyone would have participation rights or corresponding rights, as Wyoming statute calls it, to participate and share in the benefits of those projects. Most states have some unitization framework or pooling framework where you can compel parties to join into units for oil and gas, but fewer do for CO2 storage. And then if you look here at North Dakota, Montana, and Wyoming, those are all states that have a significant amount of federal and tribal land. And even those states have enacted pore space unitization legal frameworks, it's unclear whether federal lands or tribal lands could be included in those units, unlike in oil and gas, where there is clarity on that point. And then finally, looking at the geologic storage regulatory framework, these are a spectrum of whether the framework is full or developing. most states have some pieces in place, but we saw opportunities in all states to address some of these issues, whether they're on the side of authorizing condemnation for CO2 pipelines, or addressing transfer of liability, or clarifying pore space ownership. And so one of the things that we came away with after this project was seeing that there was an opportunity for states individually to address uncertainty, but most particularly for regional coordination to harmonize state and federal requirements, and hopefully to sort of look at this holistically, putting together all pieces from capture, transport, and storage into a cohesive framework in a regional way to permit, for example, capture in one state, transfer through another, and storage in a third. The last thing I want to end at, because I know I'm close to the end of my time, is just a quick list of the other contributors on this project. It would not have been possible without them, as well as with the many student contributors who did a tremendous amount of research on these projects. If you are interested in some of the particularities of this, or in delving deeper, please reach out to any of us, and we'd be glad to go through some of our work with you. So with that, Patrice, I will turn it back to you.
Great, thank you, Tara, so much. One question, you referenced the USDA taking on another segment of states. What is the timeline for that report?
The request for proposals is due on March 26th. They have put out that proposal. I can send that to you when we're off the call. And I'm not quite sure what the timeline is for them to choose the contractor who will be doing that, or for preparation of the final report.
Okay, great, thank you. And just a reminder for our participants, if you do have questions along the way, feel free to use the chat function. Tara, there I think is one in there already, and I don't know if you want to just answer it via chat, or perhaps save it for the Q&A at the end. But feel free to use that function as we go along. And next, I would like to turn things over to Blake Canfield from the great state of Louisiana to share their experience with respect to pore space and legal liability in Louisiana. Blake, take it away.
Thank you, Patrice. And man, I've always, I'm a bit nervous following someone as good as Tara. That was a lot of great information. And, you know, actually, as I was going through it, gave me some pointers on what to touch on in my talk here. So my name is Blake Canfield. I'm Executive Counsel for the Department of Natural Resources, and happy to spend some time talking about pore space and legal liability issues in Louisiana. Today, in addition to talking about some of the property rights and some of the matters dealing with liability in Louisiana, I'm also going to touch a bit on regulatory matters in the state, because they definitely have effects on both pore space rights access issues as well as liability concerns. So with that, let me get started. Next slide, please. So just generally, you know, multiple sources are showing that Louisiana has great potential for carbon sequestration with up to 2.3 trillion tons of storage potential in the state. It does currently have just over 700 miles of CO2 pipeline. The vast majority of that is actually one interstate pipeline, which begins in Mississippi at the Jackson Dome and runs to Texas for enhanced oil recovery purposes. The state is also fifth in CO2 emissions in the US, with 60% of that being coming from industry. So there is definitely great capture and transport and storage potential in Louisiana. Next slide. So a very general overview, in 2009, the Louisiana legislature adopted the Geologic Sequestration of Carbon Dioxide Act, and this kind of provides the legal framework. A lot of what I'm going to be speaking about today comes from this act. However, a lot of the property issues that we're going to be discussing are not directly addressed within that act. I guess there is enough jurisprudential guidance out there so that the legal framework surrounding pore space and who has rights and access to use pore space for storage is relatively clear. As we'll discuss, essentially, unlike some of the states that were mentioned, you cannot separate a storage or a pore space estate within Louisiana. Similarly, you cannot create a mineral estate, which is, I know, very common in most other states. Instead, what the state law provides for is what is called a mineral servitude in the case of minerals, and also can be a storage servitude in the case of storage. Within Louisiana, the Department of Natural Resources has an Office of Conservation, and within that office, the Injection and Mining Division actually currently has primacy for Class 1 through 5 UIC wells. And they just this month have applied to EPA their formal application for Class 6 primacy. So we are excited and expecting for primacy to be granted in the near future. There are strong regulatory authorities regarding oil and gas conservation and how that may impact reservoirs. There's also some pretty strong language regarding approval of reservoirs for storage. There is not, however, unitization authority as it deals with CO2 storage. There are unitizations for oil and gas, but just not for carbon dioxide storage. Expropriation or eminent domain, as it might be phrased elsewhere, is authorized for CO2 geologic sequestration, as well as for CO2 pipelines in the state. We'll discuss that a little bit later on. And most local regulation is likely preempted. And the reason I have to say likely preempted is because there is not an express statutory preemption stated. Instead, there are jurisprudentially created preemptions, almost field-wide preemptions regarding very similar and analogous types of activities dealing with hydrocarbon storage, for instance, and oil and gas activity, where the direct regulation of those activities are left only to the state governments. There are some, I guess, associated zoning requirements, not for the wells themselves, but for maybe some of the other facilities associated with storage that may fall under local government control. Next slide. So my department actually has a large, I guess, kind of varied amount of items that it addresses regarding regulation of carbon storage in Louisiana. Within the department, our Office of Conservation by far has the largest amount of regulatory authority. As mentioned earlier, they're seeking Class 6 primacy within their injection and mining division. Their engineering and geologic divisions typically work hand in glove on oil and gas unitization and oil and gas well permitting and regulation of operations. The geologic division will also probably have some role to play with the reservoir storage approval process, which I think on that they'll be working primarily with injection and mining division. And finally, there is a pipeline division which will be handling intrastate safety requirements and some other hearings that are allowed for CO2 pipelines, which we'll discuss in a bit. For state-owned property, including mineral rights as well as storage rights, that authority is vested with the State Mineral and Energy Board, and that board is actually, the staff for that board is the Office of Mineral Resources, also within the department. I mentioned the Office of Coastal Management because the bottom half of the state essentially falls within a coastal zone, and therefore any type of activity within that area often requires a coastal use permit. And that permitting process will typically have some type of location and for either the pipelines or for surface facilities. A lot of the equivalent of a NEPA, we do not follow NEPA, but the equivalent of a NEPA type of analysis will often occur within that Office of Coastal Management process for pipelines, for instance. And finally, we have a state energy office, and they are dealing with the bigger picture. They're the ones that are taking the lead regarding the MOU. Jason Lonklow, our Director of State Energy, has been very involved with CCUS promotion and outreach for several years now. Next slide. So pore space in Louisiana falls with the surface ownership. As I mentioned earlier, you can't create a separate storage estate. but instead you can be granted rights for storage in what is called a servitude in Louisiana. So in addition to the storage rights themselves within the pore space, any type of related surface activities, of course, you will also need surface rights for those as well. So you would be seeking those rights from the surface owner, as opposed to someone who owns the mineral rights or owns a mineral servitude on that property. The state and public property rights, as I mentioned, the State Mineral and Energy Board is the one with that authority. They kind of have two different paths outlined in law as to how they can grant storage right authority on state-owned property. One major thing to mention, though, is that the property the State Mineral and Energy Board directly manages is what would be water bottoms and things that are owned by the state as a public trustee. And those should be differentiated between or from lands owned by state agencies. And agencies here have a very broad definition to include local governmental entities, levy districts, and agency, cabinet level agencies as well. And finally, that State Mineral Energy Board also can grant geophysical survey rights if you want to do that prior to seeking the storage rights themselves. Finally, Louisiana law does clearly provide for expropriation authority or eminent domain authority by private entities for the surface rights needed for both the storage as well as some of these necessary surface activities, including CO2 pipeline right-of-ways. The law specifically states that you are not required to be a common carrier in order to have this right of expropriation. Prior to seeking expropriation, you must first receive a certificate of public convenience and necessity, and that is issued by the Office of Conservation's Commissioner of Conservation. And after that, if you get that, you can then seek the expropriation following a good faith effort to enter into a mutually agreed upon transfer of pore space rights. If you're unable to do that with the surface owner, you can then seek expropriation through a trial in the court in the parish in which the property is located. All right, next slide. As I mentioned, the Geologic Sequestration Act in Louisiana kind of sets forth the broader framework for CO2 storage in Louisiana, and it deals a lot with liability issues. But as we're talking about ownership, one of the primary things it does is it actually transfers ownership of the remaining facility and or project following cessation of injection operations. It transfers ownership to the state. The operator may apply for this certificate of completion, which would transfer the ownership to the state at any time 10 years or later after cessation of injection into that storage facility, and that the operator must then show that the reservoir is reasonably expected to retain mechanical integrity and the carbon dioxide will reasonably remain in place. Next slide. And I should have mentioned there, we're going to come back to a discussion of that certificate when we talk a little bit about liability in a slide or two. So reservoir management, the Commissioner of Conservation has to approve a geologic sequestration, a reservoir for geologic sequestration prior to anybody undertaking CO2 storage. And in order to do that, he either has to determine and find that the reservoir is depleted of oil, gas, or condensate capable of being produced in paying quantities, or he has to find that it has a higher purpose to be used for CO2 storage, and at least 3/4 of all the interest owners, the mineral interest owners within the reservoir have basically agreed to the use of it as a storage reservoir. He also has to find prior to this approval that any use of that reservoir is not going to lead to contamination of other formations, fresh water, or mineral deposits, and will not endanger lives or cause hazardous conditions. The Commissioner is also given pretty broad authority regarding drilling, casing, and plugging of oil and gas wells around the CO2 storage. And he is able to adopt by rule. And these rules are really usually done on a case-by-case or field-by-field basis. He can adopt specific drilling requirements, either prohibit drilling into or through the storage reservoir. On the hydrocarbon storage side, what has typically happened is he will allow for drilling through those reservoirs, but has increased construction requirements. Next slide. And so, as Tara mentioned, there is no Ferc regulation for CO2 lines, and in Louisiana there is no equivalent to a Ferc process for siting of CO2 lines. Typically, for natural gas lines, for instance, the commissioner has to approve any type of new construction, tie-in, or abandonment. That does not exist with CO2 lines, especially when we're talking about CO2 lines for storage. There are some additional authorities that are provided for CO2 lines associated with an EOR project, but I really decided not to cover that here because it has a lot of particulars I was going to try to avoid. As I mentioned, the safety requirements do fall for intrastate lines under the Office of Conservation, but interstate lines are going to be, for safety purposes, regulated directly by PHMSA. And in order to, again, be granted the authority to expropriate or use eminent domain, you would have to seek a certificate of public convenience and necessity for the expropriation authority. And that certificate is also issued by the Commissioner of Conservation upon many of the same findings that he has to determine for approval of a CO2 storage facility. So he would have to basically show that there's an approved storage facility, that it meets the requirements I just mentioned in the slide before, and that this pipeline is associated with an approved storage facility. And if he does all of that, he can issue this certificate, and then you're now authorized to seek expropriation. Next slide. I wanted to mention this trust fund that's created within that same act because it has an effect on liability. But essentially, there's a carbon dioxide geologic storage trust fund, which is intended to cover the Office of Conservation's many programs that we mentioned, the administrative costs for that. But it also impacts the release of liability, which we're going to discuss in greater detail here in a second. And finally, the specific fees that are allowed, there are annual regulatory fees, there's an injection fee that is allowed, and there are application fees that are allowed, all of which would go into this fund. Currently, the law puts a limit, though, on the total amount of money from one operator that can go into that fund at $5 million. So regardless of what the annual or the per application amount that you're paying into, that has that upper limit of $5 million per operator that can go into that fund. Next slide. And here's a list of some of the expenses that it can be used for. And I just wanted to point out that some of these expenses include remediation of a facility, the long-term inspecting, testing, and monitoring, repairing mechanical leaks. And so, reading that in conjunction with the language about the transfer of ownership, I think it's pretty clear the intent here is that this would be able to cover some of those long-term post-injection costs, but would also probably be you could spend it if there was ever an abandonment of a facility without a responsible party in the state. Next slide. All right, so the release of liability. As I mentioned, the certificate of completion of injection that has to be issued prior to transfer, that same statute that creates that transfer of ownership to the state also says that upon issuance, the operator, the owner of the CO2, any interest owner in the project or the CO2 is released from any and all liability associated with or related to the storage facility which arises after the issuance of the certificate of completion of injection. So some of the questions that we've had are, how does this interact with UIC obligations? Does the state becoming owner necessarily make it liable? As we're going to discuss in a bit, the statutes make it pretty clear the state's not supposed to be liable. So where does that leave someone if they are seeking, if they have a claim against a facility that's no longer operational? There are a couple things that can take away this release of liability. One is fraud by the operator, essentially if they're withholding or lying to try to get the issuance of that certificate. And the other one, and this is why I mentioned the trust fund, is if there's insufficient funding in that trust fund, then that would negate the release of liability. Two other things I quickly wanted to mention that the statute does is it actually puts a cap on civil liability per occurrence at $250,000, except in the event of wrongful death or substantial physical deformity or any type of injury that would prevent self-care, in which case that amount rises to $500,000. And finally, the law provides for a site-specific trust account, which can be created at the time that a site is transferred from one private party to another private party. So this could not be used at when the transfer to the state occurs, but if you are transferring it between operators, then you can create this trust fund, this trust account, and it would basically be intended to cover all potential closure and long-term liabilities for the facility. Next slide. So the types of liability released under this act, first and foremost, it says any and all duties or obligations under this chapter, the operator would be released from that, the owner would be released. And so I just wanted to point out that chapter where it's used right there is actually just the Louisiana Geologic Sequestration Act that we've been talking about. So arguably that means you would not necessarily be released from the obligations for under UIC Class 6 requirements. I do know the EPA, when they adopted their Class 6 rulemaking, was asked about this transfer of ownership, and the only statement that they had in response was that the EPA does not have authority to transfer liability from one entity to another. I don't know that that necessarily closes the door on that question, but I did want to point out the fact that it's certainly not clear. And in fact, I think the way that this is worded by limiting it to the chapter that deals with Geologic Sequestration Act, that it may not be a release from liability for federal requirements. Other requirements that are not included in that chapter are the pipeline safety requirements. Earlier, I mentioned coastal use permitting requirements. That, as well as Army Corps of Engineers permitting requirements, would not be under that chapter. So really, it would be more dealing with some of the obligations associated specifically with the approval of the operation itself. In other words, the approval of the storage facility, but not necessarily the operation of the well. So I'm not sure exactly what that gets you, quite honestly, from a regulatory standpoint. But the sentence goes further. So after talking about these duties or obligations, it then talks about any and all liability associated with or related to that storage facility, which arises after the issuance of the certificate of completion of injection and operations. And so there, I definitely see that as addressing as broad as it can any type of private liability. I think it does, raise some questions regarding the timing, which we'll discuss here in 1 second. Next slide. So it says that you're released from all these liabilities upon issuance of the certificate of completion of injection operations. There was a lot of discussion, it says 10 years or any other time frame established by rule after cessation of injection into the storage facility, the Commissioner of Conservation can issue the certificate, which then releases the liability. But it has to be upon a showing by the storage operator that the reservoir is reasonably expected to retain mechanical integrity and the carbon dioxide will reasonably remain in place. And so to me, those are two necessary conditions. You have to be at least 10 years after before you apply for it. Then you have to be able to show that the CO2 is going to remain in place and mechanical integrity will remain in place before you trigger that liability release. So it does not just automatically happen. You actually have to apply for it. And if we go on to the next slide, I think I talk a little bit about okay, so we mentioned this earlier. These are the two ways in which that release from liability can actually be undone. One is that there's insufficient funding within the Geologic Storage Trust Fund. And on that, I think that's something that guidance or rulemaking is going to be needed to give a better sense of what is considered sufficient or insufficient funding. And then secondly, this inability to intentionally or knowingly conceal or misrepresent material facts. If you do that, then you also lose this release from liability. I must have missed the other timing aspect that I was thinking of here. So it says you're released from liability from any acts that arise after the issuance of the certificate. And so I think there will be a question. Is none of this has ever been litigated, but there will always be that the ability to try to read these things different ways. What is meant by arising after the issuance of the certificate? If you have a latent cause that existed prior to the issuance of the certificate that you are claiming led to a damage after the issuance of the certificate, I think there's going to be questions as to how that language applies. Next slide. I'm not going to read all these, but basically, if you read through it, you can see that the statutes, in addition to talking about the state becoming owner, also go at great lengths to say that just by being owner, the state is not liable. And furthermore, they try to limit the state's liability to what's found in the Geologic Storage Trust Fund. And further, they try to protect the commissioner and his agents and or employees from having claims directly against themselves, so long as what they're doing is a good faith effort to carry out the purposes of the chapter. Next slide. So with that, I know I've probably used up too much time. I'm happy to answer questions. You know, try to cover a lot of the waterfronts very quickly, and I know that I probably left some stuff out. I did want to mention that our department has created an ad hoc committee on carbon sequestration, and it's a 5-member cross-discipline group of state employees. We meet approximately once a month to discuss various aspects surrounding CO2 geologic sequestration and implementing CO2 geologic sequestration in the state. We also are trying to collect information to provide that to decision makers so that they can work on any necessary rules. Finally, I've included my email address as well as my phone number. Happy to talk with anybody, answer any questions that I can. Thank you.
Thank you so much, Blake. That was a very interesting presentation. I do see some questions starting to come in the chat. So if speakers want to take a look at those, I know Kipp, you're going to be offering some comments next, but we will turn to a moderated Q&A after we have the opportunity to get some of Kipp's wisdom on these topics. So Kipp, with that, take it away.
Thank you so much. So can you hear me?
Yep.
Okay, so first of all, I wanted to thank the sponsors of this program and a host of others. So I want to first begin by thanking the Great Plains Institute for the wonderful work that they do generally, and certainly trying to advance these issues specifically, because it is going to take a multi-state effort. And when the history is written, the Great Plains Institute is going to get great favorable acknowledgement in Chapter 1, I'm certain. I'd also like to thank Steve Carpenter with the Enhanced Oil Recovery Institute up in Casper, Wyoming, who I know played a key role in putting this program together and just generally spending a career on carbon capture and storage issues, and just others. So we here in Wyoming, we are fortunate to be working on one of these DOE-funded projects. And that very much is a team effort, and I see many of the team members on this call. So we're fortunate to be teamed with the EERC at the University of North Dakota, a variety of commercial interests, including Oxy Low Carbon Ventures and Denbury, and we're very much, even though this is federally funded applied research, we are very much trying to push this over the commercial finish line, which is why all these issues are very real for us. And of course, here in Wyoming, as Tara mentioned, you know, I moved to Wyoming 6 years ago because I wanted to put steel on the ground for carbon capture and storage. And we literally are on the front lines of the energy transition. We're blessed with a wealth of fossil and renewable energy resources, and we export nearly all of that energy. So we see the impact of California's low carbon fuel standard. For example, here, much of our energy that is heading to the west is subject to a growing number of low carbon mandates. So these issues are not hypothetical for us; they're quite real. So with that, I'm just going to make a handful of observations, and I don't have slides. I'm at a point in my life where I'm kind of don't do a lot of PowerPoint slides, and I guess that's another way of saying that I'm old. But I just wanted to actually just make 3 or 4 commercial observations, and I thought we could get back to the panel and then for the moderated Q&A. And I'd also like to thank again the terrific panelists Tara and Blake. So I just want to back up, and so there may be people on this program that actually don't know what pore space is. We may be assuming a level of knowledge here. So this is a rock. Now I'm not a geologist, and if I was a geologist, I'm I would know the type of rock, I would know how it was formed, but to me, it is just a rock. And many rocks have small, minute voids in them called pores. And you measure that by a technical measure called porosity. And if those pores communicate, that is measured by permeability. So what geologists are trying to do at these storage sites is they're trying to find suitable rocks way down deep under the Earth's crust, below underground sources of drinking water, well below where you would see any, hopefully, surface impacts. And they're looking for rocks that have the capability of absorbing and storing CO2, and that are also overlain by layers of seals that literally act as icing on the cake, if you will, to inhibit, if not prohibit, any potential upward migration of the CO2. But I think some people think of pore space as that it's like, wow, there's this big cavernous balloon down there that we're inflating it with CO2, and that's not it. The CO2 is going down deep into rocks, and it's going down as a fluid, and it's not going down as a gas. So that's what this is about. And of course, carbon capture and storage, there's countless modelers and governments around the world that deemed carbon capture and storage to be necessary to meet Paris Agreement climate goals. And indeed now it's not so much trying to mitigate CO2 emissions to the atmosphere, but now they're talking about taking CO2 out of the atmosphere to avoid climate overshoot, by mid-century. And those are technologies called direct air capture. Companies like Oxy Low Carbon Ventures and others are doing great work on that. But I just want to back up and just make sure everyone knows we're talking about really minuscule voids in rocks deep underground. This is filled with pores, but to us, to a mere lawyer like me, this is just a rock. but that's what we're talking about. We're not talking about big cavernous voids. So building on the prior presentations, actually, I just wanted to make, I guess, four observations in four buckets, and then we'll go to Q&A. And again, my observations are going to be commercially focused. So this gets very real in the real world when you talk about acquiring pore space. And I'm going to pose a series of questions, quite frankly, back to the panelists, and maybe this will stimulate some questions during Q&A. But so, for example, what is the legal instrument that acquires pores? Is that a lease? Is it an outright purchase? Is it an option? And given that the CO2 is literally has to stay entombed underground in theory for infinity and beyond, that matters. What is the nature of the legal instrument and its time duration under which pore space is acquired? So that's one commercial question I think has yet to be answered, or is being answered by commercial parties through various means. When is pore space acquired? So you're going to do a project, and they said when Walt Disney was in Florida, I guess it was in the 40s or 50s or whenever that was, when he was acquiring the land to build Walt Disney World, that was all done through a series of LLCs, anonymous purchasers, and sort of cobbling it together. But when do you acquire the pore space? And do you do that while you're still trying to assess the geologic characterizations of the reservoir? Do you acquire it later? Do you acquire it when you're doing permitting? And I'll get to permitting separately, but this whole issue of when, I think, is commercially interesting. I think a related commercial issue is that do you acquire these pore space, the pore space for the entire project, or do you do it incrementally? So for a large scale commercial CCS project, it's envisioned that there'll be this heavily modeled plume of CO2 deep underground, and it will be well contained. But there may be some expansion of that plume over time. So do you try to acquire pore space for the ultimate potential extent of the project, or do you do it incrementally? I think that's an interesting legal question. So those are some of the commercial things I wanted to flag that maybe we can sort of touch upon with the other panelists during Q&A. The other thing I wanted to touch upon is permitting. So Tara's mentioned that Wyoming has Class 6 primacy, and Blake mentioned, and I'm really happy that Louisiana has just applied for Class 6 primacy. So here is the Wyoming Class 6 well permit. And let me also say here, I am not speaking for Wyoming DEQ, but it requires representations regarding surface ownership and mineral ownership at the time of permit application. And you're also required, for example, to go through to give public notice. So at the time you apply, it's envisioned, for example, that you will notify, here I'm just going to read, the permit applicant has to provide a copy of this notice to all surface owners, mineral claimants, mineral owners, lessees, and other owners of record of subsurface interests that are located within 1 mile of the proposed boundary of the geologic sequestration site. So that also gets to issues that are there permitting strategies that might lead you to Class 6 that might not require a full-blown Class 6 application right up front, because if you're still trying to assess the geology, for example, through the drilling of stratigraphic test wells, the host of geologic assessments that have to be done to prove up a storage site, when you're still doing those assessments, you actually want to trigger pore space acquisition considerations. So there's timing issues and extent issues between permitting on the one hand, geologic assessments in support of a site on the other, and when this actually gets real and you're out there acquiring pore space rights. So we can talk about some of that as well. And I do see a question. Yeah, I'm not using slides. I'm doing this like an old school lecture. The third thing I wanted to mention is what Blake mentioned, and I have to admit I'm impressed with that. I was not aware of the extent of Louisiana statutes on long-term stewardship or liability. And let me make a couple of observations there as well. There is a countless number of technologists and geologists that could testify under oath about the security of well-characterized long-term geologic storage sites. And indeed, many NGO and governmental organizations would say the same thing, including the Intergovernmental Panel on Climate Change. So this technology is believed to be for well-characterized sites, and these will be well-characterized sites, that the long-term risk is believed to be definitely manageable and certainly de minimis. And whatever risks exist, quite frankly, are apt to occur during operations while CO2 is still being injected. But once that CO2 injection stops, you're no longer pressure loading whatever that reservoir is. So that plume should stabilize over time. And indeed, it's believed in many formations that CO2 plume will mineralize and become part of the rocks. But that said, you know, Tara, you're a lawyer. Blake, I think you're a lawyer as well. I'm a lawyer as well. So maybe you could say, maybe it's a sad commentary that, you know, all these programs end up with lawyers on them, but unfortunately, you know, we do live in the commercial world, and, you know, investors require risk to be managed and the like. So there is this issue of what financial, insurance, or statutory instruments can be put into play to mitigate that potential long-term risk, however de minimis it may be. And I will say Congress has never addressed this issue. Congress last debated this issue in 2008 or 2009, and Congress has never adopted a long-term storage approach, statutory or otherwise, for long-term storage of CO2. So I think that remains a somewhat of a legal loose end, and I'm quite certain that bright commercial minds and investors can manage that. But many days I wake up and wish, you know, I'd give my kingdom for Congress just to pass a long-term storage statute. So again, Blake, I was really impressed what Louisiana has done on that point. So I think with that, I will pause, because I know we're going to get a lot of questions, and I just wanted to thank my fellow panelists and program sponsors. Thank you very much.
Thank you so much, Kipp. And, you know, I think maybe let's start off actually by addressing Kipp's questions first. I did take some notes on my end, but maybe we should start with the last question first, which is, you know, what kind of insurance mechanism or statutory things should be put in place relative to long-term storage, as Kipp called it, a legal loose end. Tara and Blake, do you have a perspective on that?
I can go first. I mean, we have obviously a somewhat limited perspective, limited to the state's interests on this. You know, I think it's pretty clear that the way in which Louisiana attempts to address that is by transferring the ownership and then putting these liability limitations and or releases. But even from the state's perspective as owner, you know, the law authorizes the state to pay for insurance that may be needed for this long-term liability. I've done a little bit of research into that, and I sort of get mixed messages, you know, from folks saying that it's, you know, the insurance community already provides the exact type of insurance that you would need, all the way to other people I've talked to say, well, you know, there just is not currently an insurance policy really that's been created, an insurance type that's been created for this long-term liability. So it's something that I'm going to continue to look into. But as far as how it is dealt with in the state, I mean, it definitely looks like the intent is there, that transfer of ownership and release of liability would attempt to address it.
I'll jump in here as well. I think, so North Dakota and Montana both have statutes that would allow liability transfer to the state. And, you know, I think this is probably the missing piece in what we have in Wyoming, because it does create a question of what happens at the end of these projects. Of course, we have processes for site closure under the UIC regulations, for ending reporting under the greenhouse gas reporting program. But what happens with the CO2 that's being left in the ground in perpetuity? Wyoming statutes, for example, say that title to that CO2 remains with the injector, but can we expect these commercial entities to have a perpetual duration? At some time, I think it's reasonable to imagine that they will wind down and distribute assets and liabilities. And so the question would be, who would hold on to that title over potentially a geologic timeframe? And when we look at some of the issues, and Jada, I'll introduce all of you to her, who is a policy analyst and research scientist with SERPA, with Kipp and I, and I were talking about when we look at like the orphan well issue, and thinking about parties who, are looking at a time scale of storage and operations that does not match up and is misaligned with the time scale of corporate entities and commercial projects. Can statutes and liability transfer programs basically realign those in a way that makes sense, that they're sure that there's adequate mechanisms going forward? So I think that's a really important thing to address. And there was a question in the comments about understanding the comfort level of investors relative to liability and risk. And I think having a clear off-ramp and regulatory program for exit would certainly address some of that uncertainty and discomfort.
And I can sort of jump in on that too. Those are great answers. And this is maybe in direct response to Blake. I suspect, again, we have some really savvy commercial parties. I can just see here on scanning the chat function, I suspect that the commercial world, in the oil and gas space in particular, that they've probably cracked that nut in some way, or maybe completely. I do know on insurance markets, and some of this information may be dated. It used to be, I mean, the U.S. expert on this used to be Lindeen Patton, who, and I think she still is, although she's no longer at Zurich. She was at Zurich and wrote those first insurance policies that I think are still in effect at the ADM project in Illinois. But what I always understood with insurance products, and again, I would not want to be quoted on this because it's been some time since I've called an insurance company, but it used to be that you could not, I mean, you couldn't go to Allstate, for example, or you couldn't go to Travelers and say, I want a policy that lasts for 500 years, or I want a policy that lasts for 100 years. You could get a policy, but it would be renewable year by year. Now, again, maybe that has been mitigated in some way through commercial approaches that I don't have direct access to now. But again, I would just love for an elegant statutory solution here. So, yeah.
Thanks, Kipp. And, while we're on the topic of long-term liability and such, and actually going back to Jada's questions in the chat function, this is a two-parter, and maybe Blake, starting with you, do other states have geologic storage trust funds? And then specific to Louisiana, do you expect that there will be litigation around liability transfer and the trust fund that is set up in your state?
So anytime someone asks me if I expect there to be litigation, my answer is always yes. I definitely expect there to be litigation at some point. But, I think the question too is talking about, legislation possibly providing additional guidance. I think that's almost certain. We've had a lot of interest from legislators in the state. As I mentioned, this act was passed in 2009. A lot's happened since then. Many of the things I think that were in the minds of the legislators back in 2009, that predates, for instance, excuse me, that predates the Class 6, rulemaking, final rule by EPA. And so I do think that there's a desire to kind of understand where the law is coming from and see, is there a way to provide greater clarity? Do we need to make some of these policy changes, to answer some of the questions that I raised or that are still out there? I actually would be I'd be pretty surprised if 2 years out from now there have not been at least attempts at correcting or changing things legislatively. So I think it'll kind of be a little bit of both. I think you're going to have some jurisprudentially answered questions and some that will be answered by statute. You'll also have some that are probably going to be answered by rulemaking, because some of the very specific questions, such as the trust fund itself, like exactly how is that going to be managed, and how are we going to determine sufficiency of funding? A lot of that, I think, can actually be done by rulemaking.
So this is Kipp. I can jump in on that too. And Blake, I can tell you've spent much too much time reading obscure Federal Register notices. I remember you said in your presentation that EPA did make that statement in the preamble. I forget if it was to the proposed rule or the final rule for the Class 6 regulations that said that the clean, that the Safe Drinking Water Act, I guess it was, did not authorize the transfer of liability, that you couldn't hand it off. And of course, that was not in the rule itself, that was in preamble language, but that's just kind of hanging out there. And I did want to say, you were mentioning that there might be statutory fixes. I think if there are statutory fixes, it's going to be at the state level. I just think for those of us that have been at this for decades, it's been a long time, literally decades, since Congress enacted a new substantive environmental law. The Clean Air Act, they're regulating CO2 emissions under the 1990 amendments to the Clean Air Act. Many of these statutes are half a century old, and I just think that part of this is that EPA is doing its best to shoehorn these issues under statutes that are, in some instances, are half a century old, and were never really contemplated, these sorts of issues. But I'm pessimistic that Congress is going to come up with a elegant fix here. I hope I'm wrong. I think Congress is going down the incentive path for this issue. They're not going down the path of substantive statutes. So I do think the states are going to be leading on this. And again, all credits to states like Louisiana and Wyoming for doing their best to be ahead of the curve here. I do think, though, the most elegant solutions could be provided at the federal level for some of this, and I'm not overly optimistic I'm going to see that in my lifetime. I hope I'm wrong.
Thanks, Kipp. Tara, do you have any comments on this point?
I do think that there's a lot of things that can be done within the existing authority that agencies have under FLIPMA, at least. I think that there's room for federal agencies to conduct rulemaking sort of within that existing authority, as well as the ability to address some of these things piecemeal. Of course, it would be awesome to have a comprehensive federal storage law that ties up all of the loose ends, but I really do think it's possible to make a lot of headway and move the ball forward significantly with very targeted pieces of federal legislation, coordination with state action, and then both state and federal rulemaking.
Thanks, Tara. And so I'm looking at the time. We do have just more than 10 minutes left for Q&A, which makes me excited and happy. We're going to dive into pore space next and kind of the series of questions that Kipp teed up. But I just want to put the speakers on notice and give you a little time to think, because I do want to round out the webinar by you offering what you see as the top considerations and issues that the states that are involved in the CO2 Transport Infrastructure MOU should think about tackling, and potential recommendations they should be making when they are developing their action plan slated for release later this year. So we'll get to that, but again, back to pore space issues, and I'm going to throw two questions at you at one time here. One is any thoughts that you might have on compensation approaches to pore space? And then along with that, maybe comment on the legal instrument that acquires the pore space. So we'll start there.
I'll start here because I've had the really fun challenge of drafting pore space leases, as well as grants of pore space easements and reservations of pore space rights in conveyances. One little, I guess, like plug is to all of the attorneys on here is if you're doing a real property law or contracts, think about pore space as a resource and as an asset, just like you would think about minerals. And as you are conveying property or even doing long-term planning in estate planning or in land, think about how are you envisioning the pore space resource? Is that something that could be a separate value stream that you could transact with? So I'll address first the question of structure. And again, this is a very rapidly or evolving area. And so there are a lot of different approaches, and I don't think it has gone towards one being predominant yet. And it really depends on who the parties are. So when I have worked with, for example, a state agency looking at a lease or a terminable interest has been more interesting than, for example, selling or conveying a specific subsurface strata outright and severing out maybe that injection zone and conveying it in fee, or granting a perpetual easement that would allow injection, very similar to the produced water disposal easements or chemical disposal easements that you probably have seen in other contexts. But for a surface owner, for example, they may be concerned about some of these long-term liability issues and be more interested in selling the pore space and saying, if you can tell me that you only need this one formation at these depths, I would, in states that allow this, sever that out, convey it to you, in fee with rights of ingress and egress. And then, I've sort of removed that from my estate, and to some extent what you've done on it and liability issues, maybe that creates some insulation, particularly if there's an opportunity to expressly limit the right of that interest to use the surface or have any above ground surface occupancy. So in short, I've seen conveyances, reservations, leases, and easements. And then for how you structure the payment, I think I actually don't have any data points on the amounts being paid for pore space, but I've seen a variety of different approaches in that area as well, including one-time payments, annual payments, fee per ton payments, and then staged payments where different amounts of consideration would be given upon receipt, for example, of a Class 6 permit, maybe an initial payment during the seismic and site assessment process, and then following up with other payments. So I would say that this is a really exciting and rapidly evolving area with a lot of really creative solutions being developed.
So Tara, I'll just weigh in. I was just going to say, Tara, I'm actually hoping to retire early. So I just want anyone to know, if anyone wants to, if they want the pore space under my house, I'm a motivated seller, and Tara and Blake can help you negotiate the deal.
Kim asked an interesting question, if I can just jump in here, that how would an annual payment work in perpetuity? And that's a great question. I have not seen an annual payment in perpetuity. I have seen annual payments during the injection period and during the monitoring, verification, and reporting periods. But I think that's a great observation. At some point, it has to cut off.
If I could just I'm
So
sorry,
I'm going to have
Patrice.
you hold for 1 second
Yeah,
because
absolutely.
I want to make sure that we get to, I'm selfish, so I want to get to the advice you have for the states. But I'm going to take the concept of stacked storage and I'm going to make stacked questions. So we will stay on pore space. And so Kipp also asked the question. So Blake, feel free to weigh in on the first two, and I'll let you start off on all four. But also, when should you acquire the pore space? And do you acquire the pore space for the entire project, or do you do it incrementally? So those are the stacked pore space questions.
Sure. So I'll just kind of add one thing on to what both Kipp and Tara mentioned regarding kind of the structure of this, an additional consideration as the state, whenever we're looking at these things, we have prohibitions within Louisiana about actually severing and or transferring, something. We don't have fee simple, but something the equivalent of a fee simple sale of property that's held in the public trust. So in a lot of ways, I think the state is somewhat kind of hemmed in on what it can even consider doing. Within Louisiana, it's sort of like we're given the option of leasing the property as the state, or we're given the option to enter into what's called an operating agreement. But it almost, when you read these operating agreements, they are more similar to a servitude or an easement. So I just wanted to mention that that's kind of an additional consideration that you may have as the state as owner, that you don't as a private entity sometimes. And also as agencies of states, they often will have limitations on the property that they own often is donated. And the donors have typically put limitations on either the use or the ability for the entity, the agency to sell the property. So anyway, just additional considerations regarding that. As far as timing, this is a question we've discussed quite a bit at the ad hoc committee that DNR has. We've had kind of feedback from several folks that I think are large landowners themselves and don't necessarily need to worry about the property ownership side of this quite as much, where they are starting to look at acquiring property. And to them, because they have a large piece of property they already own, they know that if they're going to do this project, it's going to be located there. And so they are kind of running on all cylinders at once, trying to acquire additional property, also filing for approval with the Commissioner of Conservation, and also applying with the EPA, all at the same time. But I will say, from a regulatory standpoint, something that we see a lot, for instance, with class 1 hazardous wells, in some of the other larger permits, often the way that it seems to be structured is there's some sort of option, that the party is basically paid some amount to have an option to ultimately purchase the property. And while they are doing geophysical surveying, that's kind of where things stand. And then they will start the application process prior to exercising that option. They'll wait to see if they get the permit first.
Thanks, Blake. Tara, do you have a perspective on those questions?
Well, so I think, for example, like getting the rights in the actual place where you're drilling your injection well and injecting first is imperative. If you were only looking at, where you need the remainder of the rights, it is a combination of balancing your risk exposure under tort law for subsurface trespass, as well as looking at the regulatory requirements. So, Wyoming, for example, its unitization statute requires you to have basically 80% of the storage complex and the affected area. Those are terms that aren't particularly well defined yet, in order to get a unit to bring in those other owners for storage. So that's going to drive it there. But whether you're looking at the area of the actual CO2 plume or the affected area where you may have pressurization changes, I think there's some questions there that haven't yet been flushed out in agency rules, and that are going to be resolved as project proponents start bringing these projects before agencies. You know, there is a mechanism, for example, in Wyoming's law, if you were a pore space owner who feels like there's been migration under your property, to petition the agency to have the unit expanded and have your pore space included in that injection unit, and then the agency could hear evidence and testimony on the size of the plume and determine whether that was necessary. So at least the law seems to contemplate the idea that the initial footprint could expand over time.
Thanks, Tara. And so we will go through the chat and make sure that everyone's unanswered questions get answered, but we're going to do a rapid fire round of your best advice to the 7 states as part of the CO2 Transport Infrastructure MOU on key things they should be looking at for their action plan in October. And Tara, we'll kick it off with you.
Well, so based on our study, we found the issues that had the most sort of regional impacts would be pipelines, which is one of the reasons that the transport MOU is really exciting, and having coordination, particularly among how those pipelines are sited and the common carrier requirements being harmonized among them. The other piece that I see is if you imagine a storage complex that would cross state lines, particularly looking you know, at whether there would be a way to create interstate units, which would combine property interests on both sides. There's some issues with how you would provide sort of due process and who would manage that. And then one of the other things that came up in the comments was the commodity pollutant classification. One issue if you're transporting in a regional project is that CO2 could be a commodity on one side of a state line and classified as a pollutant on the other. And so being clear that how sort of the regulatory frameworks would apply to transported CO2.
Thanks, Tara. Kipp, you're up.
2 things. I think every state should apply for Class 6 primacy if they intend to do carbon capture and storage. That's for two reasons. The local regulators know the geology. This isn't about cutting corners on regulation and permitting. This is going to be stringent under all scenarios, but the regulator that's closest to the rocks, I think, is going to get a better answer on storage. Also, the regulator that's responsible for the determination of conversion Class 2, Class 6 is the state agency as opposed to federal EPA under a primacy state. The other thing I would say is that the role of the private sector here is absolutely critical. I suspect the private sector is ahead of where federal and state regulators are, and I don't mean that as an insult to any federal or state regulator. I'm a state employee here as well, but I think the states have to work collaboratively with commercial parties, and we all know who they are, who are probably well down this path of siting storage sites, coming up with risk mitigation approaches. So I would encourage the states to be teaming with commercial parties to help get these business models and risk management approaches done. That's it, I'm done.
Thanks, Kipp. And Blake, you get the last word.
Yeah, I mean, I don't know what's left. I think Tara and Kipp kind of hit the ball at the park there. You know, one of the things that kind of in line with both Tara and Kipp, the siting of pipelines, I think, is going to be huge without there being a Ferc type you know, entity. I think trying to come up with some way of managing that, you know, is definitely important. And then kind of more along the lines of what Kipp was talking about, you know, if all the states are going to be seeking and getting Class 6 primacy, then definitely them being able to work together for storage facilities that maybe cross state boundaries, I think is going to be very important. I know, you know, we've reached out to Texas, for instance, on this very thing. You know, one of the major industrial corridors in Louisiana is in Southwest Louisiana, not far from the Texas border. And so we definitely foresee the need to be able to coordinate and communicate with our other states.
Thank you, Blake. So we did go a couple of minutes over, but I think it was well worth our time. Fascinating discussion today. fantastic panelists and presentations. We will be sending out a recording of the webinar to everybody who registered. Feel free to follow up with us, and be sure to take in the University of Wyoming's Class 6 webinar next Tuesday. Have a great day, everyone. Thank you again.